I'm considered a member of the public. I'm monitoring, but because I did not RSVP with my physical location, I can't be considered officially here. Hi, this is Allison. I guess since this is my one opportunity to talk, I'll do so in the public comment period. Oh, it's not? Okay. Um, I guess just to frame kind of, and this may be the plan anyway, but just to follow up on a couple of questions from last time. Um, I think our, at least on behalf of the Assembly Judiciary Committee, we would like to see a solution that allows the Commission and the State Bar to work together in a mutually agreeable way, whatever the arrangement ends up being. We'd like to see basically the same work being done by the Commission, whatever the formal composition of the Commission ends up being. We think it's important for the Commission to have a strong input in its future and its preferred formation, and whatever we can do in terms of clarifying existing law to allow that to happen, we're happy to do that. And that's it.
Has left the conference. Has joined the conference. Has joined the conference. has joined the conference.
Dealing with administrative agencies for basic necessities of their lives. And so it's not controversial. We're not going to the legislature. We're not taking a position in conflict with the bar at all, I wouldn't think. But it's just something that is important to us and I think is something that's clearly not a priority to the bar. So where would we come out with that kind of issue, which take away the controversy? It's just something we feel is very important and at the center, at the heart of our work. And it's something that is not a priority for the bar. And is that a good way to sort of look at the conversation we're having now, is how would we work our way through that?
So if I may, I think indelibly etched in my mind are Catherine Blakemore's Venn diagrams. I think I'm going to go at my last memory would be just before I pass away is going to be your Venn diagram. But I think that there are Board of Trustees priorities, and there are access to justice, the California Access to Justice Commission priorities. And there's going to be some that are going to overlap, and those are the easy ones. Mm-hmm. If we say we think this is important and you say absolutely not a problem. So I think the communication, having clear lines of, when the new Access and Inclusion Director, Inclusion and Access Director Access and Inclusion Director is in place, then I think having clear lines of communication and reporting and all that sort of stuff I think is easy to handle. And I think that also the commission coming up and saying, here is our agenda, our proposals, our work plan, whatever we're going to call it, that we take to the Board of Trustees on an annual basis and say, this is what we're thinking. And I would anticipate that there's 5 items on our agenda, our work plan. And the Board of Trustees is going to say, 1, 3, and 5, we're good with, not a problem, go forth. 2 and 3, however, or 2 and 4 rather, are outside of our purview, to use sort of a judicial branch phrase, outside of our purview. We don't think that self-represented litigants are a big issue. They're a big issue, but they're not an issue that we want to expend our precious resources on. But that's something that goes to the heart of what the commission does. And so while we may not disagree on the merits, where are we then going to be effectively told no, because our interests, I think, are going to be broader than the bar's, is my guess. Are we going to effectively be told no by either we don't think self-represented litigants, just to pick on somebody, is something we want to deal with, or we can't afford, or whatever. So effectively, we don't disagree, we're not going to be able to carry the ball. And that's a concern, I think, that of mine is, what does the resource piece look like? So the question becomes, okay, the Board of Trustees says self-represented litigants isn't our thing. Can we then go to someone else and seek resources to do it? Or, as the Board of Trustees said, nope, 1, 3, and 5, that's it. And so I think the area where there's clear, and we've been around for 25 years. I don't think we've ever been in conflict with the bar. I have a difficult time thinking that we would be in conflict with the bar. I'm assuming everyone is going to deal in good faith, that the commission is going to deal in good faith, the Board of Trustees is going to deal in good faith. If the board says, no, this is adverse to our priorities, then we're going to sit down and talk about it. Maybe we could change each other's mind. Maybe not. But I think that the more troubling area to me is where we're in an area on our side of the Venn diagram that's not on the bar side of the Venn diagram. And that's the issue, is what does that look like to me?
Yeah. So, so you said a word that makes me happy, which is work plan. So in my mind, the way the world would work, we've got the Board of Trustees every year establishing the strategic plan, goals and objectives, and the advisory bodies to the board developing work plans that are consistent with that. I think the issue you raised, Judge Uhas, goes sort of to the same sort of concept of sort of there's black and white and maybe there's a middle ground, right? So the sort of one side of that is the bar now has, and we're very proud of having them and very happy to have them. The bar now has access priorities. And our plan is to work collaboratively with the Access Commission on accomplishing those priorities and those projects and initiatives. So one way that the bar could look at it is say, those are the priorities that the Access Commission is going to be working on. The other way, the other sort of extreme is the Access Commission says we get to work on whatever we want to work on, so there. And the middle ground is sort of similar to the way we're talking about legislation is the Access Commission, and I agree with you. The bar will in January, as part of its strategic planning session, define what its purview is with regard to access. I think it likely that the Access Commission's purview will be larger. I think that is a logical assumption. But sort of that middle ground could be similar to the sort of the legislative concept that I threw out there, that the Access Commission comes after the bar adopts its strategic plan and comes to the board or one of its committees and says, okay, we see your strategic plan. We put those 3 things on our work plan for the year. In addition, we're putting these other things on the work plan, which are within your definition or broader than your definition. Board looks at those with the same eye toward, is this adverse to our interests, even if it's broader than our priorities? If it's within sort of the bar's purview, and if it's on the bar's priority list, then it's a bar product that the Access Commission and the bar jointly, that we're all working on. If it's outside of the bar's priorities or purviews, then it's an Access Commission product that the board has to say, is this is this going to create an issue for us, right? Is this a conflict, not because it's broader than our sort of purview, but are there conflicts out here that we know of that you don't, and this is adverse to our interest? That's sort of, again, sort of right, the sort of the 2 extremes and the middle approach that we can sort of talk through.
The one thing though that strikes me is it's a resource conflict when additional items are added outside, and so there's always a conflict if additional things are added outside of the board's strategic plan. And the question Judge Uhas raised is, if the state bar can't give resources to those things, how does it look, and does it make sense for the commission to go outside of the state bar for those resources? And I don't know what the problems are associated with that legally or just administratively, and I would be curious to get some input on that issue.
So I think that's a very good point, because a lot of it does come back to resources. And I think one of the things on the agenda for today is to talk about the resources. And at least from the last working group meeting and working on the commission, my sense is it's not a very large amount of resources, but it's a resource question, and it's partly at the heart of this. So I think we have to answer the resource question. But for me, the words that strike me and that I'm writing down is the conflicts and how that conflict is described, because I think that's very important. This is the devil's in the details. So in addition to the resource, we have to answer the resource question and how that would look when the commission's doing something that are not the priorities of the bar. But I'm really focused on the other types of conflicts that are being mentioned, and I hear it, interferes with the interests of the bar, adverse to the interests, or conflicts. And it really matters what that means, because and I think it might even be easiest with the work plans and the priorities, but with the legislation and the amicus briefs, those come up without the planning, right? Legislation isn't something necessarily somebody in this room is sponsoring. And so there's proposed legislation out there that may have a very large impact on access issues. Same thing with court cases. A court case comes and it may have, and so if it's not something that's on our work plan, if it's not something that we've discussed, but something comes up about self-represented litigants, funding of the courts, court reporters for, and other things that have been talked about. And I think the devil's in the details when we talk about these examples. I think what's being proposed is, and maybe this is where we have to really move the discussion at some point, is that is the commission going to be able to take positions on those types of issues, file an amicus brief, talk to legislative staff on issues, whether that is, that impacts something on the agenda, or can they only, or would the commission only be able to take positions if they get approval from the bar board or its designee? And in that case, it's only if it doesn't conflict with what the bar thinks. And what does that mean? Because there are a number, again, I think we've talked about this at the last working group, but there's something important about the Access Commission being able to speak on topics of access that maybe the bar can't for all number of reasons. And I think that's something that we want to try to preserve.
I have a question and then a comment. When the bar is developing its strategic plan, and I hearken back to my experience with the Judicial Council and its numerous committees, when you're working on your strategic plan, is input taken from the various committees and the commission as the bar is developing its strat plan and the priorities? Just a question, Donna.
Yeah, so the way the access priorities were developed that got into the strategic plan this January, was that there was a joint meeting of our programs committee and the Access Commission Executive Committee in November, so this time last year, where they talked about a variety of things that the Access Commission thought were important priorities. Based on that conversation, we put together panels for the board's planning session, at which Selena Copeland, who's sitting in the audience, was on the panel with Lisa Pruitt, who's a member of the Access Commission, and we talked about rural issues and loan repayment, attorney desert issues, and sort of from that, we developed the objective to do a justice gap study. There was a panel that looked at paraprofessionals and what Washington and Oregon are doing on paraprofessionals and whether we should do that. So there's a strategic plan goal to be looking at that. So that's the concept that we intend to sort of formalize a process. Now, this year, we're having that same meeting with our, the joint meeting in November with our Council on Access and Fairness, because an area where the board strategic plan is deficient is on diversity and inclusion. In other areas, we're incredibly strapped for resources, so this isn't a time for us to be adding to the strategic plan in other areas, but that would be the concept that we have talked about with the Access Commission, that on a going forward basis, each year they would participate in helping the board develop the concepts for what the boards and the bar's access initiatives and projects and objectives would be, and that's what would find its way into the strategic plan.
And traditionally, we haven't done that, but this last time I thought worked really well.
Okay.
And so I think as a model on a going forward basis, that's a good model to take forward.
Okay. And then, so if each of the committees and the commission has that input and there is some level of communication and coordination as those priorities are developed, I would imagine when the commission then develops its 5 projects on your work plan or whatever you end up calling it, hopefully, 9 times out of 10, there shouldn't be an issue, right? And I think Amos brings up a really good point, because in our world, things always come up that are not on the work plan. We experience that in almost every single committee with the council, as Donna knows. It happens every year through legislation, or something happens in a court or something. something somewhere in the state, and all of a sudden there's an issue and it's a hot topic. You know, at least with the council, the way we've addressed it is so that there's recognition for certain urgent needs. So if there's a designee, then, you know, there's a phone call that goes on to say, you know, here's why, you know, we need to act on this in the next 5 days. We can't wait for the next board meeting, et cetera. And that person has the authority to say, no, I understand the urgency. I agree. It aligns with everything. Go forth. So, you know, I think there are solutions to some of these issues that are being brought up, and they're legitimate issues. These things happen, and the situations are going to come up. But if we can outline, you know, protocols for dealing with that, I think you can still address it.
And I totally agree. And I think this comes back to your earlier point about oversight versus control, because if, for example, you know, the United States Supreme Court is considering now, you know, the right to counsel in immigration proceedings.
Yeah.
Right? So if the commission thinks this is something that's important that needs to be weighed in on, you know, it wasn't something that was generated by the California Bar or by the California Access Commission, but it's something that's happening that has a very real potential impact. And, you know, I don't know what the bar would say. I think, and I don't know what the commission would say, because there's a separate amicus committee without judges, and there's a whole process. And anything that comes out of that committee would have a disclaimer that says it's not from the bar. But the question is, yes, for oversight, yes, for a process, yes, for informing and communication, but who makes the ultimate decision, right? And that goes back to the control part. So
It does.
I 100% agree that we should be able to work together with oversight and communication. The real issue is who's deciding, you know, and I think if there's a conflict, there could be a discussion too. But the question is who is deciding.
And I think there, you know, through some communication, if you develop some sort of conflict resolution clause or protocol, that should outline, here's how the last say, you know, and it could be, you know, 2 members from each area or whatever. I leave that up to you guys, but I think there is a way to develop a conflict resolution component to whatever agreement is reached that has that, you know, this is the final say.
I agree completely. And I think how it's worked historically, and I don't want to overstate this, but I think how it's worked and how the commission has been comfortable is with a disclaimer, right? Which makes it very clear that when the commission is issuing a report or filing a brief or taking a position on legislation, that is the commission or a subcommittee, if it's the amicus of the commission. It's not speaking on behalf of the bar. And at least up until now, that's, for the commission, had comfort that that avoids any conflicts with the bar speaking on behalf of, I mean, the commission speaking on behalf of the bar. And it sounds like there's discomfort with that. And I think that's where, because I think if there is going to be an autonomy and some separate voice from the bar, this is sort of fundamental to that, in that if the commission is issuing a report or taking a position on something that it's not speaking on behalf of the bar, there won't be a bar board of directors vote on any of those things unless it happens to be one of those Venn diagram things that fits squarely in the middle.
I could see where that would be an issue, and that's going to be the tougher nut to crack, I think, because if the commission is under the umbrella of the bar or any other entity for that matter, when that entity issues a report that's separate from the overarching organization, the public doesn't view it as such. It will be viewed as a product of the state bar. You can outline it in the very first sentence of your report, and nobody's going to focus on it because they're going to think you're a part of the bar. I mean, that's just...
Just to add on to that, I would imagine the legislature would have the same issue or the same impression, which I think, speaking as a member of the trustees, is an issue and a concern for me, right? Confusion is not what we need on these really important issues. So,
yeah, it's very hard for the you know, legislators in Sacramento to understand when the commission is coming to them talking about stuff. Is that something that the state bar is in agreement, or the state bar isn't in agreement? we want to send a consistent message.
I don't think the legislature is that confused about what's the bar and what's not the bar.
But the
Margie.
commission is part of the bar.
Or whether it's coming from the commission or an official position of the state bar. I don't think that there's that confusion. I'm not confused by that.
Well, you're savvy when it comes to the commission. You're definitely very sophisticated, and obviously state bar stuff, much to your chagrin.
Yeah, I think legislators are also sophisticated, so I'm just gonna
Our
put that
experience
into the record.
Thank you. I wasn't intending to suggest that they weren't. The legislature's a big group of people, and they listen to the public.
and they're always changing.
Right.
And frankly, if they don't like something that's being said, they could blame the bar. If they like it, they'll praise the bar or not. But it's dependent on personality very significantly, and it's just a risk. And I mean, I think there's been some issues in the past, and I can't speak to them. I've just heard about them third hand. So a disclaimer doesn't do the job if there's a true conflict between the position the state bar is taking on something or not wanting to take on something and the commission wanting to take a position on that. It is a challenge. I don't know if we go forward on the assumption we can work everything out and just come up with processes, or do we make the assumption there's going to be something without any question that the commission's going to want to do that's the state bar doesn't want to? And can that ever be solved if the commission's going to be part of the bar? I think that's a hard question.
Toby, then Karen.
Could, this is Allison Merrily.
I guess what troubles me a little in what I just heard.
Oh, Allison? I'm sorry.
Could I jump in with some public comments since the question was really about...
Hold on, Allison, we can't hear you. Hold on.
I think when I asked that the speaker get turned down, somehow that turned down you. And so hang on for half a second.
Is that any better?
No, it's our end, not yours, I think. And they're working on it. Can you, we need a sound check.
Okay, here I am. Can you hear me?
That's great, thank you, yes.
Okay, great. I just wanted to weigh in with some public comments since the question was, is there confusion among the legislature about a position taken by the commission and whether that's reflective of the bar either in a positive or negative manner? Honestly, I think it's both giving too much and too little credit to the legislature to assume that we're confused by that. I think it's not necessarily important to us. I mean, if the commission were an independent nonprofit entity, I think the legislature would consider the position of the commission as the position of the commission. And I don't think that's necessarily different than if the commission were associated with and ultimately under the auspices of the state bar. I think the legislature takes the positions of the commission as the positions of the commission. I think if there's something that the state bar should be doing vis-a-vis the commission, I think that the legislature judges the state bar for its actions vis-a-vis the commission, not necessarily the other way around. So I think the commission is a well-established entity that can stand on its own 2 feet in terms of the positions it takes, either, whether it's under the auspices of the state bar or independent from the state bar. I tend to think that disclaimers are effective in communicating that the commission is not speaking on behalf of the state bar. And I think we deal with this in a myriad of different ways. I mean, we have groups that come and lobby us, and we might deal with one chapter of the California Medical Association that
has left the conference.
they're not speaking on behalf of the entire California Medical Association, for example. I think we can figure that stuff out on our own. And so I actually would discount the sort of legislative confusion argument. I think in terms of the authority of the commission to take positions that may not be kind of consistent with what the State Bar wants to do, I mean, I think that's possible, and it could be accommodated. And I think, for example, the commission could be authorized, and whether it's in statute or whether it's in a rule, it could be authorized to take positions on legislation and to file amicus briefs on its own behalf, as long as those positions are not adverse to the interests of the State Bar. And basically, it could operate as the State Bar would have a veto. It doesn't necessarily have to approve all the positions, but it would have the authority to step in and say, no, this is so far outside, where we're comfortable with you being, because you're still associated with us as an organization, that we just have to stop it. Versus a lot of things that are slightly outside, with the Venn diagram issue, slightly outside, the lines in which we want to color for the State Bar, but not so far that we have to put our foot down and say this is really problematic. So, I think it's all a matter of just opening one's mind to, accommodate the relationship that you want to have. And so I think you could do it without confusing the legislature, and you could also do it in a way that would ultimately sort of preserve the integrity of both organizations. And that's the end of my comment.
Allison, I think one of the concerns, though, is the ability of the State Bar to veto anything that the commission wants to take a position on. And that's what we're struggling with, is that, does that really work in a good governance structure? And would they be better off not having the oversight of the State Bar, so they have the freedom to take whatever positions they want and things they feel they need to? I think that's the hard question that we're trying to struggle with. And I don't see the bar saying, no, we don't have any say.
No, I think ultimately, that's where the commission, it's important for the commission to say what it wants. It would obviously have more independence and authority if it were independent, but it may also want to have a slightly less independence and authority by retaining that relationship for whatever reasons it chooses. I'm not qualified to judge that, what the right step is for the commission itself. But I think if the parties could get comfortable, it certainly could work that way. And I think it would also depend on very clear process for how the commission would advise the State Bar of what it's doing. And so the State Bar would have plenty of advance notice about whether there's some unusual case where it needed to step in and say, no, this is too far, this is too much, this is, we're not comfortable with this, and so we have to use our rare authority to stop it.
So I'm just curious, how often have there been these disagreements? Are we talking about a hypothetical that could occur in the future?
Yes.
But it's not happened in the last 25 years?
Toby has much more institutional experience than I do.
I can't recall any, it depends on how you define it, of what the conflict is. I can't recall any time in the 25 years that the commission did something or wanted to do something that was directly adverse to a position the bar was taking. Right. We've never gone to the legislature and said, no, don't raise dues, when the bar said we need to raise dues.
So I think
there's been issues that we might have taken on that the bar didn't think were priorities, didn't think were important, but that the commission did, like the administrative agency project. Some of them are things where we got out ahead of the bar, like the language access issues, the rural advocacy issues, where the bar hadn't seen those as issues until after the commission issued a report saying, look how terrible this is and we need to do something about it. But I can't recall, the administrative agency things, I can't recall something where we took a position directly adverse to the bar.
And I think part of the issue is and again, I've said this at every commission meeting and every stakeholder meeting where it comes up. The commission has acted in the past with relative autonomy because that is what the bar gave it, right? So
Right.
Nobody's saying that the commission did anything inappropriate. But because of that relative autonomy, there wasn't the oversight. There wasn't necessarily the communication and the interaction. So what I can't say is, had we had those discussions, how many times would the bar have said, "Ooh, geez, I wish you wouldn't have gone there." I think though I want to take us back a little bit, and I think whether we're talking legislation, whether we're talking, reports, sort of initiatives, projects that the commission is doing, I think that a quintessential question comes down to the notion of the commission isn't independent. The commission is part of the bar, and so to the extent that the bar, again, sort of thinking of the scenario where there's an understanding that the commission's definition of access work is broader than the bar's, and that the bar says that's fine, I'm not standing in the way of that, but nonetheless saying, but we need to see a work plan, we need to have a conversation on legislation or urgent matters as they come up, to say, is there a conflict with the interests of the bar? Is this antithetical to the interests of the bar? Is there a problem with the bar or the court or sort of whatever those parameters are? And we could define those parameters of sort of where it is. But it's at some point, where we've come down is sort of a question of, if the bar says there's a conflict with the interests of the bar, does the commission get to do it anyway, or does the bar's information that there's a conflict with it, is that sort of the decider? I don't think sort of the focus on legislation versus is necessary. I think it really is sort of looking at the initiatives, the projects, the work of the commission, and ultimately somebody does need to decide either yes, the commission gets to go forward over the objection of the bar, or no, if the bar has an objection because it is antithetical to the interests of the bar, not because it's broader than the purview of the bar, but because it's antithetical to the interest, then does that sort of stand as the decision?
But that then leads me to a resource issue, because if then the commission says, okay, well, if you don't agree, we want to still go off and do it on our own, are you not going to be using bar resources to be able to go do it off on your own?
Well, and there may be a different way to look at that question. It may be the bar, through the strategic plan, through the assistance of the Access Commission, on an annual basis going forward, will be developing the bar's priorities.
Right.
It may be that the bar says those are the things that we can provide resources
Based on your
for.
resources,
Right.
yes.
We're
Yes.
identifying how many priorities we can handle based on our resources. If there are other things that the Access Commission wants to do, that it puts on their work plan, that are sort of within or exceed sort of the boundaries of the bar's purview, but are nonetheless broader than the identified priorities, then the bar can't provide resources to those. The commission presumably could get sort of external resources to do it. But I think that's separate and apart from the question of, if the bar says no, this is in conflict with the bar's interests.
Yeah.
Having the
They're two
commission still go out and do it with other resources, I think, is a different question.
Yeah, it is. It is.
Karen has been patiently waiting.
So, just listening to everybody, it makes, I'm glad to see people are kind of narrowing in on the issues that I think are really at the bottom of this entire discussion. And, you know, when I hear conflict and conflict resolution, there's technically, I don't really see it as a conflict per se, but, you know, there is the overlap piece that both, you know, that the State Bar has collaborated with the commission, and everybody kind of agrees, okay, all good, borrow, fund that, resources are made available, that's fine. Then there is the area of projects that are broader than what the State Bars has defined for its strategic plan, but not necessarily in conflict. You mentioned that. And I think there could be criteria developed by both the State Bar on the one hand and the commission on the other to kind of, you know, guide in those cases where perhaps it's not veto is kind of a bomb. I don't want to use that word. But, you know, perhaps those projects could proceed because they're not really adverse to the State Bar, and perhaps with other funding, then those projects can be pursued. But there may be a group of projects that would be adverse to the bar's interests, and specifically, I'm kind of thinking of projects that would require additional resources of the bar to be put towards, like if you know, if there was some project or responsibilities put on the bar that would have to be, you know, funded by the bar, you know, for an access project. And I'm sure, you know, nobody would dispute the need for that sort of project. But if it puts a financial burden on the bar because the bar then has to develop, you know, some sort of administrative, you know, housing and oversight for a project like that, then I think there needs to be discussion, because something like that would be kind of adverse to the bar's ability to carry out its core functions of, you know, regulation and discipline. So, you know, I think there is, I think, a category of potential cases where it would be good for the State Bar and the Access Commission to come together and to try to figure out the criteria for that, perhaps. And it's not just criteria that would allow the State Bar to say, you know, this is really adverse to our interests, but also kind of a recognition perhaps on the commission side where that line would also be, and with some recognition that, you know, that the State Bar is funding you and has a lot of other responsibilities that it needs to, you know, fulfill in terms of its regulatory functions.
If I can just add a little, I'm sorry, if I can just quickly add a little bit to what Karen is talking about. Every entity that I've ever known in my 40-year career always wants to do 20 more things than it is able to do because of lack of resources. So I think I really appreciate where the commission is coming from in terms of having certain priorities that the bar may not be able to agree with for whatever the reason is, okay? But that doesn't mean that you can't put it on a list and do it when there are resources available or the following year or anything like that. I know of no entity that can say, I want to do these 5 things and I want to do them in the next 12 months. And these are resources are, that's just an issue for everyone, especially nowadays, right? So I still come down to, I don't know that there really is an issue if you really haven't experienced this in the past. And I think, you know, a comment is all this next statement is going to be, but what comes with increased coordination and communication is there has to be some level of trust that both sides are working towards what is in the best interest as it relates to access to justice. So, I think trust is going to be a really important piece of this thing, and it seems like that might be a gray area right now.
Sorry, I was just going to offer a public comment to say, as the envisioner of the Venn diagram, I think as it was contemplated, the items I'll say to the left, because that's how I like to align myself, the things that the bar's not doing, that the Access Commission might want to do on its own, was never envisioned to be using bar resources, that the commission would always find its own funding or use sort of donated time, and that it would always be clear that those work products were done with a disclaimer on it that could then, signify that this was separate work product. And I think in this model of the Venn diagram, it's really to say, is there really one size fits all oversight? Or are we comfortable with some gray area that would let the Access Commission, do things on the left that were really on its own and understood to be on its own? So that's really the question you're trying to wrestle with, is what does oversight look like? And if the bar feels like, and part of what I'm hearing is like, no, that doesn't work, that they're really just because of where the bar is now, it has to have this oversight, sort of in the way that Joanna or others explained it, then I would suggest the opposite. So Venn diagrams work both ways, right? And so if you start from the place of the Access Commission is independent, but there's a desire to work collaboratively with the bar on agreed upon priorities, it sort of eliminates that need for oversight, right? So you have instead an independent Access Commission, and you have the bar over here, and there's still an understanding to collaborate around this set of common interests and work through them, but then you avoid the how are we going to sort out what does oversight look like? And I think kind of as I've listened to this discussion, I was very wedded to the Venn diagram and the way that I initially thought of it, but I see the complexities and what the bar is really struggling with in terms of how it views governance, to say there's just a different way to think about how that collaboration works with an independent Access Commission that collaborates on an ongoing basis about agreed upon priorities. So that's my public comment.
I was hoping to get a little tutorial again on where the funding for the Access Commission comes from and how much has been spent on the Access Commission in the past. Did we already talk about that?
No, you raised the question at the last meeting. I didn't really answer it. So I don't have the specifics on the funding. In terms of sort of the travel and the catering costs, it's $25,000 a year. In terms of staff resources, I would estimate that at a low end we've provided 2 FTEs, and at the high end closer to 3.5, maybe as high as 3.75, but I'd say about 3.5 FTEs over the sort of the course of several years. That's sort of how it's been allocated.
Sort of like 3 full-time people a year?
So again, sort of at the low end, it's been two, and then at the high end, it's been about 3.5
And what's
a year.
And what's funding that? Isn't there a
general fund?
There's a general fund.
Yeah, that comes
None
out
of the
bar's,
affinity programs, nothing, just the general fund.
It comes out of the bar's general fund.
Okay.
So in my experience, I'm going to push back just a bit. In my experience, I can't believe we've had 2 full-time employees working 100% of their time on commission stuff. They may be doing some commission time, but they're also doing other things as well within the Office of Access and Inclusion.
So if I were to take, say, sort of harken back to, when Kelly Evans was here, Kelly would estimate that she spent 75% of her time on Access Commission work. Louisa at the time spent about 80 to 90% of her time on Access Commission work. Sharon and Rodney, maybe 50% of their time. Terry Mesa, some part of her time. So sort of as between sort of 5 staff at that time. It was probably about 3.5 FTEs equivalent of work. So that's how I came up with the math.
But then Access Commission time would also be other bar access issues as well.
Right, and so that's where there's
that's a fuzzy part.
It's fuzzy, and it's also that's where the bar hasn't had a lot of its own access work before,
Right.
but now it does, and so now that time gets spread a little bit differently, and also what we haven't done as we've been, and I explained at the last meeting how we're transitioning our staff in the Office of Access and Inclusion to have a much broader portfolio. So everybody would have a grants portfolio, an access portfolio, and a diversity portfolio. We've been able to transition the grants work, so everybody's got a piece of that. We haven't yet transitioned the access work or the diversity work. So ultimately, there will be sort of more people with smaller pieces. So it'll add up to, and I can't tell you exactly what it adds up to because we haven't finished that work of allocating that out. And this discussion will also sort of help sort of understand what that's going to look like.
Has the briefing work that you all have been engaged in been done by attorneys with the state bar, or
Nope.
have all pro bono?
So again, I'm not probably the person to talk to exactly, but I will say that it's my understanding that the amicus work has been done entirely outside of the bar. The bar has not spent one dime on any of the amicus things that we have done.
And just to make clear, there's been 2 that I
Right.
can think of. I mean, it's not something that we're doing every week.
2 over 25 years?
Yeah.
What about legislation? Has that also been, when you've engaged in,
Has
has
left
that
the
been pro
conference.
bono, or has that been, the 3.5 full-time equivalent staff going in and talking to the legislature?
There has, and again, I would look to Toby, we have written letters that have been drafted largely or entirely by staff members in support of this, that, or the other thing. Bar staff has never, to my knowledge, set foot in the legislative building, in the Capitol, advocating on behalf of something the commission has advocated.
I think that's right. And it's a letter supporting a position, and both state legislature and, increased funding for the Legal Services Corporation, or, even things at the national level like that. But it's, none of the state bar staff has done lobbying. I can't remember if we've had any of our members doing lobbying on behalf of the commission.
I think Selena does lobbying, obviously, on her thing and her stuff. I think that when Kelly Evans was here, she was actively involved in trying to increase the Equal Access Fund. And so would you say that's lobbying on behalf of the commission? Not really. I wouldn't, because I think the bar was behind that initiative to increase the Equal Access Fund. So I'm still kind of mystified how we get to 3.5 full-time employees, but I'll leave that alone, so.
Jody?
So I just wanted to clarify my understanding of the last public speaker's comment. The way I interpreted that, and correct me if I'm wrong, is akin to being separated from the bar. If the commission is independent but works in tandem with the bar, that to me sounds like how it's been, which has been the issue. So that it's akin to just being separated from the bar, and then you would supposedly have a contract or something for services, right?
So I think that I don't want to speak for Catherine, who's remarkably articulate, but I think under her Venn diagram, it's a little bit the way it's been, but not exactly. We've been independent of the bar, the way that we were set up 25-ish years ago to be independent. We've been fully staffed by the bar. And so I think there would be a memorandum of understanding, probably of some sort, that would continue to have us work together on those areas where there's the middle ground where we would agree on. And then we would be on our own as a standalone 501c3 or whatever we are, on our own as a standalone entity.
Right.
The bar would be a standalone entity. And then I think we would continue to work together on things.
Okay.
I want to make one other comment, then I think it looks like Catherine wants to perhaps. I think one area that we keep talking about the administrative agency report. The Board of Trustees has taken no position on the administrative agency report. It's never gone to the Board of Trustees. We have worked for a number of years on this report on on best practices in administrative agency, access to justice, that sort of thing. The last pronouncement from staff was that it's not going to see the light of day. And I think that in fairness to the bar, as the bar has sort of looked at its various commissions and subentities and whatnot, that they have taken a position, not that the administrative agency report is adverse to the bar in any way, we're just not interested in it. It's not within our purview. I don't mean to be.
Gotcha.
I'm not trying to be flip. It's not within our purview. Why would we do this? And so I think that's something that I'm concerned about because that's the most recent example. And that's actually the only example where it's, my understanding is the bar said no. That's the only example that I'm aware of.
So if I could just clarify that. So the administrative agency report came up at a public access commission meeting, and we were talking about the board's governance in the public interest governance review, what we've termed the Appendix I review, and Leo was doing the introduction of the Appendix I review, and somebody said, so for example, like what wouldn't be something in the bar's purview? And she said, well, like this administrative agency report that you just talked about, this isn't something that would be in the bar's purview. I am unaware of any statement that, this will never see the light of day. It was part of that conversation. But as far as I'm aware, I'm still waiting for a draft to, come to me.
But-
So I did just want to say that there's still an ongoing discussion about that. It was something that it was like, yeah, this doesn't seem like it would be part of that was the way I heard it.
Why would we publish it?
Well, what was said is, why are you working on that? That's not something we're gonna do. It was pretty strident.
There was a line drawn in the sand pretty clearly.
And if I could just address this, because I think it goes to the heart of the matter, really back to your earlier point in question. I think the way to say it is past performance is no indication of future performance, because I think the bar, if it had a veto up until now, and it did in fact have a veto up until now, it's just that there was no active oversight, and that was by design. Right. The real concern comes, and it might be partly trust, but it really has to do with the changes at the bar and the changes in the bar's view of its role and the changes in its bar opening up to certain access issues and wanting to define those and have specific. So there really is a new world order, which is now the oversight and control is going to have teeth, and the bar, both the bar staff and the bar board, is going to be interested in reviewing and vetoing, or having the ability to say no. And veto might be the bombshell, but it does come down to, on what basis would the bar say no if the commission is doing this on its own dime and it's doing it with a disclaimer? It really would have to come down to an example. I mean, from my view, to an example where there really is an adverse interest. And how narrow is that? There was public comment earlier from Allison about this being a very rare event. Hasn't really happened before, but again, we're in a new world where there's now going to be oversight. And I have to say, so if we could really narrow what the review is, what the parameters, what really is a conflict or adverse, and that really is adverse, but I struggle even in that, even with the example of, well, maybe it's additional resources of the bar. I mean, one of the potential legislations that came up in the last thing was mandatory reporting of pro bono. And it just is odd if the commission can't take a position because the bar resource issue might be, is it really going to be the case that the commission can't comment on legislation that has such a substantial impact, even with a disclaimer saying we do not speak on behalf of the bar, and whatever the position is, for or against, it seems odd.
But aren't there ways to outline how those disagreements can be handled? To me, that's we've been talking about the conflict piece of it and how to resolve that and coming up with some sort of a resolution to that, because that seems to be the area that is maybe a bit more troubling for folks, right? Isn't that the same thing as if if the commission is independent and there's an MOU, you'd be outlining this in an MOU anyway?
Yes.
So what is wrong with the bar having oversight? I personally refuse to use the word control. Having oversight in my head is increased communication, coordination, etc. And then having an agreement that outlines, should there be a disagreement, this is how we are going to resolve the disagreement. Period. Done.
But the
Maybe it's too simple. I don't know.
No. I think that's not too simple. I think it's exactly right. I think that the question is, so let's say that we agree to resolve the conflict by having 2 members of the commission and 2 members of the board of trustees sit down and they haggle it and they take a vote. And it goes against the commission, Lost votes before, 1 votes, not a problem. Goes against the bar wins votes, loses votes. And then so the question is then, can we then go forward? Or is it the bar's, it's ultimately sole legal custody, if you will, since that's my world.
Depends on how we lay it all out.
Right. Is it sole legal custody that the bar says, great, wonderful discussion, fantastic points? No.
There was a comment, and I want to say, Amos, you said this last time, and I wholeheartedly agree with this last time, where, the bar has a variety of different committees, and the commission is different. I agree. I mean, even at the Judicial Council, we acknowledge that our access committee is different for a variety of different reasons, probably the same reasons that you would argue that your commission is different than the other bar committees, right? And even at the council, we reduced all of our committees, but there was recognition that, wait a minute, the access committee and the chairs outlined all the reasons why it was important for them to have more members, and I'm just using that as an example. And the council said, no, that's fair, that's legitimate, we agree with your reasoning, and so that's one of the largest committees that the council has. So I think there's a way that you can still, have some level of flexibility. This isn't only about laying, these issues out on the table and having some conflict resolution protocol. It's also about both sides having a little bit of flexibility. You can't put even if you have a document and you both have agreed to something, it's not set in stone. That's not how our world works, right? There has to be this common understanding and give and take. And we're all adults, and I think that really is achievable.
And if I could respond, I agree 100%. And I really like your framework of oversight versus and separating out control, because I think if there's a process and votes and agreement and increased communication and increased trust in terms of working it out and modifying positions or doing things different ways, I think it can all work out. But it does come down to the control, because I think, and this is what I was saying earlier, I think from the commission's view, or my understanding of the commission's view, one of the solutions is the disclaimer. One of the solutions is to say, we haven't come to an agreement. We have some concerns. You have some concerns. But we're not speaking on behalf of the bar. And the bar can take its position or decide not to take a position. And the commission can go ahead, and it's not speaking on behalf of the bar. And right now, I feel like that is either being taken off the table or there's really not comfort with it. And then I don't see how conflicts get resolved. If the commission is always speaking on behalf of the bar, then there's no autonomous or independent voice.
That's control.
Yeah,
Right.
that's control.
And I think I would be willing to go even one step further, which would be using Justice Fujisaki's reading ahead in the book comment, where the bar, where the commission would say, speaking on behalf of the commission, we think that this should occur. We understand the downsides to the bar are this, and this. We understand the reasons for our position are this, and this. And so at the end of the day, we, the commission, think that you should do this. And so acknowledging that there's another side to all of this, and that the bar has a position that, they don't want to create a new bureaucracy and it's going to be expensive and all those things. But as I've said before, I think access is messy, and I'm concerned that on something as important as mandatory pro bono, whatever, that the sole voice about whether it's a good idea or a bad idea is the bars. And I think that the beauty of our system is all these voices, the First Amendment, all these voices, talk back and forth, and ultimately we get to the right decision, which is ultimately the legislature's job. But you have to have all those different voices. So I think an acknowledgement, like I said, maybe, an agreement, acknowledgement, what, there's a lot of downsides to this, and we understand that. But this is what we think, and this is what we think, not what the bar thinks.
So what I would like to see, what I think would be helpful is, I don't know that the state bar, I don't know on things like the mandatory pro bono or, mandatory reporting requirements, that in those cases there had been any conversation beforehand. And I think if there had been a conversation beforehand, the state bar could actually inform you kind of why it is, why it's potentially an adverse, and I don't want to say adverse, but why it affects the bar in a way that the bar cannot support that effort. And, especially when it has to do with, what will this require of the state bar? Mandatory reporting. Okay, so does that mean the state bar has to go after people who don't have to, who aren't complying with that duty? What are the consequences? There's a whole range of consequences to something like that. And I think part of the whole discussion about communication and understanding between, the Access Commission and its priorities and kind of the state bar and what it needs to deal with in terms of its, regulatory functions and, limited resources is more of an understanding of, oh, okay, well, you pointed out there has to be a creation of an entire, compliance function that, it's not, it just seems that on an issue like that, had there been, if there, let's say it comes up in the future,
right.
If there could be a conversation, upfront, kind of before, active lobbying,
right.
That it would inform, I'm not saying that, I just think that everybody is better off and access is better off if the decisions are not made in silos, but are fully informed by kind of the consequences that result to kind of all the stakeholders.
To be clear, we have never taken a position on mandatory pro bono, 50 hours, any of those things. And also, I completely agree with what you just said. I think talking about it and working it out, I think makes a tremendous amount of sense.
If I could jump in, I think I can't imagine a situation that couldn't be worked out, and I think part of that process could include a disclaimer. That could be part of the discussion, whether or not that would serve as, in the rare instances that there wouldn't be agreement, we are all, we're all under the judicial branch, we're all under the court. We do have an ultimate authority we can go to, but the commission isn't separate from that. They're part of the judicial branch as well. So I think there is a route we could go to resolve the ultimate conflict, but I don't see that happening. Because, I mean, everyone's adults, and, with discussion and communication, I think we can come up with good solutions.
So I also think, so I'm just using this as an example, okay? I know. But what might also occur with the conversation happening up front is to iron out the actual problem, so that, the main part of what the commission seeks to accomplish by whatever, the new project is, or the proposed legislation is, at least, this happens at judicial council. We have, defense counsel and plaintiffs counsel working together all the time, and I'm sure the legislature would prefer something that, has agreement among all the stakeholders, so they're not getting lobbied by one side or the other about whether something is a good plan, a good idea or a bad idea. So even on something like that, where there could be a problem with creating, more financial burden to the bar, there may be ways that, that particular project could be accomplished or presented as legislation that has already kind of smoothed out whatever the issue was that may be adverse to the bar.
So can I just say, if you don't mind, I agree with all that. I think one of the fundamental things we've already sort of accomplished is saying we need to improve communication and collaboration and work better together, and that will be better for it, because especially with the bar's new access priorities, there'll be more discussion of access and overlap in what we do. I think this example is very helpful, because there was two pieces of legislation. Toby, correct me if I'm wrong, but there were two separate pieces of legislation. I think it was this last session. One was mandatory pro bono, and one was mandatory reporting of pro bono. Neither of those originated with either the bar or the commission, and as far as I know, neither the bar nor the commission officially weighed in one way or the other. I do think communication, coordination, and some process to discuss it is the right answer, but the ultimate question for me is, if can the commission take a position that the bar doesn't necessarily agree with, right? And hopefully it doesn't happen, hopefully it's a very rare case, but is the commission a separate voice from the state bar, or can it only speak when it's consistent with the state bar? And I think that is a fundamental question, because the other option on the table that we've already discussed, an independent commission, would address the resource issue, would address this conflict issue, it would be an independent voice. And that is how it has been up until now, although by design, we're coming into a new world. So the question is, can we devise a system where hopefully it's not necessary, and in almost all cases, or all cases, we're able to reach agreement? But I do have to worry, because I'm a lawyer, what about the situation where there's a report we want to issue, or amicus brief we want to file, or legislation we want to comment on, and we do the coordination, we try to resolve it. And in most cases, we can work it out. What happens if we can't? And does the disclaimer work? Does it work to say, we're commenting on this legislation, we're filing this amicus brief, we're doing this report, we do not speak on behalf of the bar? It's worked in the past. The question is, does it work going forward?
So I think in my mind, the disclaimer issue is much like the resource issue we were discussing before, and that there are sort of multiple buckets here. The way I was seeing it was, if the the report, position, whatever, the project or the initiative, let's call it that, if the project that the Access Commission is working on is outside the purview of the bar, but within the purview of the Access Commission and not in conflict, then I see that as a project that would come out with a disclaimer that says, this is a project of the Access Commission, this is a report of the Access Commission, this is a legislative position of the Access Commission and not of the bar, because it's broader than what the bar itself would do. But again, so I don't see the disclaimer working in the instance where there's conflict. I think where there's conflict, and this is the critical question. In my mind, where there's conflict, as staff to the bar, I would say the Access Commission is part of the bar, and if the bar says there's conflict, these interests are adverse, that the Access Commission wouldn't be able to move forward on those. But I don't even have a vote at this table. So, but I think that's an important distinction. I see the disclaimer applying to those things that are broader than the bar's Access Commission. And I think the board's going to need to be able to say, are they okay with the Access Commission moving forward in your instance where there's disagreement, with the board saying, no, we are asking you not to move forward because there is conflict with the bar's interest, with the court's interest, it's adverse in some particular way. And so that's where, for me, that I think is where the rubber meets the road. Well, that's what this stakeholder working group is about, right? We come up with some proposal that gets presented to the Board of Trustees in January. And that's ultimately, right, the board can't be having this discussion in any group setting, or in seriatim, right? That's what Bagley Keene's all about. And so there has been no opportunity for the board sort of to have that discussion as a board. That's what the January meeting after the issuance of a report from this group would be.
And I think this is extremely helpful and moving the discussion forward quite a bit, because I do think this is the hybrid model, right? It's very clear, and I think on our agenda to talk about an independent commission, what that would look like, how that would be funded. But it certainly would address all these concerns that we've been raised about conflicts in resources, conflicts in positions. It also sounds like with the different staffing model that's coming, that also might raise some different issues that we haven't seen before. So the independent commission addresses all of those. I think the question is, can we address this fundamental issue of control? I think the control is right, because I think the oversight we can, I think the reporting, the communication, the collaboration, the working on issues together, we can. And I think we're going to be better for it. And I think that's going to cover the vast majority of issues that come up, and hopefully all of the issues that come up. But I think the crux is this control issue where there is conflict or disagreement. And again, maybe it doesn't come up a lot, but my sense of the meetings we've had up until now, including the commission meetings where we've had, it's very clear that bar staff and maybe the board has a very different view of what the commission has been and what it's going to be. And at least the proposals have been the extreme that we started with, which is it's just another sub-entity. And I think this comes back to the comment of, is it going to be different? Is there going to be a different kind, a materially different kind of deference to the commission to set its agenda and its priorities with oversight, with communication, but that the idea is it is a separate voice than the bar, and it may be taking positions that the bar, for whatever reason, is not comfortable. It might be a resource issue, but I'm less concerned, frankly, about the resource issue. It's just,
Has
this
joined
is
the
something that the
conference.
bar hasn't taken a position on, isn't comfortable, and you're a sub-entity, and so you can't take this position either. And that's a vastly different world.
Yeah.
But I don't think that's what we've been saying.
I don't think so. Mm-mm. So, do we know what the commission and the bar's compromise position would be on the conflict control piece of this?
So I think that, I agree with Donna that that's sort of the whole discussion. What I've sort of started thinking as I'm talking is the disclaimer piece, right? So we come and we talk and we collaborate and we work out almost all issues. But if there is disagreement, maybe we take a vote and maybe that we have some other system, especially if there's particularly sensitive issues like legislation was raised. If there's particular issues that, or the bar raises, hey, this is a problem because it's really adverse. But the idea would be the commission is overseen. There is oversight by work plans, by setting priorities, by having better communication. But that for its independent priorities or in taking positions, it takes it with a disclaimer that it's not speaking on behalf of the bar. And that's at least how I envision it. And again, also with the resources. So I think it's already been discussed. If the commission's doing something that's not in the Venn diagram overlapping, that it's finding, alternate funding for that.
How about the bar?
I agree with what Donna said. If it's not directly in conflict, I could see how that could address it. If it is directly in conflict, I don't see how it does, because the commission is still part of the bar, and we have multiple committees. You don't like sub-entities, committees, commissions, and we are all under the same umbrella. And we can't, as a board, we can't have those committees under us taking positions that are directly contrary to the best interests of the bar as a whole. It wouldn't be good governance, good oversight, whatever word you want to, good control. How's that? So I think that would be a problem in those rare instances, if that ever happens, that the commission wanted to take a position contrary to the best interest of the board. I mean, ultimately, the board could decide we don't want the commission to exist anymore because it only exists because of a board rule. And we don't want to go there if the commission started doing that. There's got to be a better solution. I don't think a disclaimer is enough. You want to weigh in?
I was going to say, I think that's the important distinction, and it's that tiny percentage of the time where there was going to be a direct or a detrimental conflict, right? And ultimately, somebody's got to decide when that happens, and ultimately, it's probably going to be the board, based on the reasons that Joanna just mentioned. So, I mean, if we build into the protocol or the process some system whereby every reasonable effort is made to find a way apart from that direct detrimental conflict, whether it's disclaimer, whether it's something else, but ultimately somebody has to be the judge, right? There's a bunch of judges in this room. You know what it's like to actually have to make a decision. And if it's the board that does that, then I think that's where we have to land.
So one comment that I actually hadn't given any thought to up until right now, I think if we do a hybrid, that we would need some kind of statutory protection or some kind of protection that would not allow the Board of Trustees to say, see ya, you're done. That thought had never crossed my mind until now. So I think
That wasn't a threat.
No. Well, I got that, but I think we would need, because then you've got sort of in the background if you really annoy us, and so I think that puts an entirely different spin on some of this discussion in my mind. I'm sorry. Having said that, we've been going for quite some period of time. So do we want to take like 5 minutes and stretch for a moment, or because we end at 1, right?
I think lunch is sitting outside.
Oh, okay. So we wanted to grab lunch real quick, and then is that sort of the sense of the organization here? Okay, great. Let's do that.
Anyone watching and on the phone, we will try and resume the meeting at 5 after 12. That's lawyer time, so you can calculate that however you like.
has left the conference. Has left the conference. has left the conference. Has joined the conference.
thank you all very much for returning. I apologize for what's undoubtedly going to be lunch sort of sounds. My suggestion, however, would be at this point that we go to number F on the agenda, because we have about 50 minutes left, I think. That we go to F and talk about considerations for separation. And I think I would again ask for public comment, if Catherine and Selena have public comment. And then also, Allison, if you're here and have comment as well. I don't know whether you do or whether you don't, but Catherine?
So I sort of outlined a vision for what independence would look like in my prior comments, so I'm not going to repeat that. Jody, I thought, asked a fair question about that, and so just to respond to kind of that piece of it, if on the left is the commission's independent work that the staff, we're not using bar resources for staffing or for any other purpose, but I would see in the middle area where we're working on agreed upon priorities as being the area where if the bar chose to do so, they could enter into an MOU or a contract with the Access Commission to do a portion of that work in conjunction with the commission. And it almost seems to me, given these sort of complicated, which I don't think are quite theoretical questions about oversight or who gets to make the final decision, it really does sort of seem easier to operate from a here's what the work the commission is doing over here as a separate organization, because then the bar is not left in the place of trying to provide oversight and entering into those, sort of more tenuous areas where it's going to be difficult, I think, to resolve it. I guess the last thing I would say is I'll actually give the General Counsel's office credit for working through this disclaimer. That was, the commission filed 2 amicus briefs. With the last one, there were questions about whether the commission should or shouldn't file an amicus brief, and it was ultimately suggested by the General Counsel's office that we use this disclaimer to be very clear about this is not work that's, we're not speaking on behalf of the bar or any other appointing authority. So that's sort of how that came to be out of bar staff. I can't really speak to whether that was because the bar was okay with it, but wanted it to be clear that we weren't making a position, or the bar was in the place of like, this is not, we really don't want you to file it. I don't think there was ever that gradation. I think my other observation is that some things have to happen on a really fast timeline. There's a statutory timeline for filing an amicus brief, and sometimes conflict resolution processes can exceed what that might be, and then the end result is by default either going to be filed and people are going to be unhappy, or it's not going to be filed and different people will be unhappy. So.
Hi, good afternoon, everybody. I'm Selena Copeland, the Executive Director of the Legal Aid Association of California. We're one of the appointing entities, but I, as an individual, have attended, I believe, all of the Access Commission meetings for the past several years, and I also serve as the co-chair of the Rural Task Force of the Access Commission. So that's my background information and why I'm always at your meetings. And so I just wanted to reflect really briefly on what I saw at the October meeting, and what seems to continue to be a theme is that it seemed that then everyone agreed that the importance, the independence of the Access Commission was very important, and also that the Access Commission cannot continue in its current design, with status quo. And so really what the bar is really concerned with is not just the staffing resources, but just the appearance that anything the Access Commission could do, even with a disclaimer, that it could be seen or perceived as being done in the bar's name or with the bar's blessing. And so sometimes when there may be issues in conflict, if the Access Commission continues forward and says it's just us, the Access Commission, the bar just is worried about all sorts of public perception or legislative perception or even judicial perception. But I have to say that one of our concerns at LAC is just the the hampering of all future work of the Access Commission with or without a disclaimer because of the resource issue, and specifically because of Bagley-Keene. Um, I know when we made a lot of changes at the Access Commission to make sure we were following Bagley-Keene, it really felt like work went to a standstill. Not only did staffing resources feel shrunk, where it doesn't feel like we have 2 FTEs now, because so much of the FTE, I think, is really focused on Appendix I work, but it feels like we have 0.5 FTE right now, and work isn't happening, and Access Commissioners want to do the work. And so the consequence of that is that actually all the volunteers and the appointing entities are doing much more work than we have in the past. And with Bagley-Keene, all of our online collaborations and emailing that we've done in the past, we've had to make sure we comply with Bagley-Keene, that we notice meetings, that everyone notices their location. And it's very hard to do work that is meant to be efficient and nimble and quick. And, all these publications, it's so hard to work on a publication with Bagley-Keene. And so I've just seen that shrinking of resources. And, I wanted to quickly call attention to the Rural Task Force work as a really great example of, then versus now. And with the Rural Task Force, some of the people here on the Rural Task Force, and we have our notice meetings, and we have various working subgroups that trying to write these 4 publications, policy papers on what happens if you're a rural Californian and you have a housing problem, what happens if you're a rural Californian and you're a victim of a disaster, which from October to now has been a series of wildfires, and what does that happen for people in rural parts versus those who are in cities. So we have all these papers written, another one on rural attorney deserts and one on immigration. What happens if you're a rural Californian who are an immigrant looking for services versus in an urban center? And LAC is spending a substantial amount of our own resources writing these papers, as is Professor Lisa Pruitt at UC Davis. In contrast to the last time around when we did our Rural Task Force report, Teresa Mesa was the main staff and the hub of all the work. We had at least a dozen people drafting various sections and paragraphs and pulling together client stories, but Terry pulled it all together, published a report, and it really was her child because it was all her work product of pulling it together. Whereas now we have basically 0 state bar involvement. They schedule the meetings and attend phone calls, but 0 involvement with drafting. And it is a very different picture. It's very hard with all of these other smaller cash-strapped agencies trying to pull together our resources to do this report. And I actually think that these are state bar priorities to look at what happens to rural Californians. And if we had a different staffed access commission, I see a clearer role for state bar staff to do more work in that area. So that's just one example of how all this Appendix I work has impacted what I believe is a true work of the Access Commission of making excellent publications, having public comment. We anticipate at some point, if the State Bar approves us publishing these reports, that we'll be able to use them in media, in op-eds, letters to the editors, in media usage, and trying to get the we actually worked after the disaster in Sonoma County last time around, working with local television media to get legal aid stories placed. And I think that this is something the Access Commission could do a lot of if we had different staffing. So it's just one example, and it's one of the reasons why, although I liked status quo. I liked 18 months ago when the Access Commission got to do whatever it wanted to do, and we had the state bar resources. I think that LAC is really starting to lean more towards independence and an independent entity working in partnership with the bar, similar to what LAC as an entity does now. We partner with the bar all the time. We separately have a contract with the bar to run a website and to run conferences and trainings, but it's very clear the work that LAC does separate from the bar and the work that we do with bar resources. And then we have tons of partnerships that the bar doesn't pay for any of our time, but we work very closely with the Office of Access Inclusion staff to say, here's what we're thinking on this. Here's some damage control we may need to do with some pieces of legislation that were proposed that were not our ideas, but they are happening, and how can we steer the ship in a different direction? And those are very close partnerships with the bar staff, although not using bar funds. So that's just one of the models that I think there are other separate nonprofits that work very closely with the bar. And interestingly, I think with California Lawyers Association being a separate entity, LAC is already pledging to work with them, and we'll be meeting with their leadership, and we've had lots of really great conversations because they're elements of each organization's mission that very much overlap, and we should not be working in silos. We should be working together, and we are. And there's just a time where you have to figure out is this a partnership? Is this a collaboration? Who's paying for what? Are we making it very clear that we're just working together, but we may need to separate at some time? And I think that that's happening with California Lawyers Association with LAC. It's happening with the State Bar with LAC. And there may be a time with the Access Commission where it needs to move towards that. So that's it.
Thank you for your input. The sections went through a very similar process when Bagley-Keene got imposed on the State Bar. It didn't work with their structure, and they had a very hard time getting things done. And it was one of the impetus for them agreeing that separating from the bar would make sense. They have a lot more freedom. They're not bound by our rules and regulations. They can sell alcohol. They're very excited about that, I'm sure. But Bagley-Keene was a big part of it. And it's very important for this organization for transparency that we have it. But it doesn't feed the needs of some of our sub-entities, the way, I know you hate that word, the way they've been doing work in the past, and it does hinder things. It is a huge advantage if part of the organization separates to get out from underneath Bagley-Keene so they can go back to operating the way they did before it was imposed on us. And then you can make your own transparency rules. But thank you for raising that point, because I think that is an important one for the discussion of whether or not separation makes sense.
So if it's okay, I'll like to weigh on this. So Selena has been at all of our meetings and has a strong, oh, yes.
Allison, can you start over?
That was looping back. No, I was looping back.
Okay. I'm not going to start over.
So, and I have experienced on some of the commission subcommittees exactly those kinds of issues. I think of it as resource issues because, the commission members are doing a lot of it themselves or getting pro bono without the same kind of staff assistance on certain things, and these might be outside of what is on the strategic plan of the bar, but also the Bagley-Keene has really changed the dynamic of how the commission is able to operate and do its work. And some subcommittees were really delayed in being able to have meetings and who can participate. It really has changed the dynamics in a negative way that in terms of getting the work done. But I also want to say that the separation possibility, I have also been, the status quo is fine, why fix it? And it has worked so well, but it has changed over the last year quite dramatically. So we're no longer in the status quo of how it's worked for the last 25 years. The resources is a big issue. So I think because the changing of the staffing, both in individuals that have staffed the commission, but also in the change of approach and the amount of time that individual people can have. It's just, I think staffing going forward is going to look very differently than it is. And right now, I just don't know. It sounds like an independent commission with funding and dedicated staffing would be able to support all of the priorities of the commission, not only some. And so it would just be a fundamentally different staffing model if it's independent in a way that might really be beneficial. I still come down to the stuff that we were talking about earlier, the conflict issues, because I like the commission being a part of the bar. That's how it's always been. I think when I think about the commission and the access source, I also think about the state bar and the state bar being on the forefront of these issues. But I do think in addition to the conflict issues, the Bagley-Keene and the resources in particular, if there was a dedicated stream of funding that the commission wasn't trying to raise funds all the time, it could focus on their mission, and there was dedicated funding, and then it would be funding for all the priorities of the commission, not just the ones that overlap with the bar. That would feel like more like how it's been operating, as opposed to not only the conflict issues, but the resource issues and the Bagley-Keene. So I'll just say that independence really does feel more like the status quo in some respects than otherwise.
And just to add to that, going back to Jody's point earlier, with independent resources, we would have that same discussion of how much of our priorities can we address this year. We're still going to have that discussion. It's just that we would have that discussion and make our own decisions rather than the bar making those decisions for us.
So when we talk about separate dedicated funding, are you, and then funding is a component of this item on the agenda, are we talking about public funds? Because if it's public funds and you're a separate entity, aren't you still subject to Bagley-Keene?
Yeah, it's a very good point. So I think it just depends how it's set up. I think if it's set up by legislation, the legislation can address whether Bagley-Keene applies or not. So I think that could be addressed separately. I think the bigger issue is where's the funding coming from? Because again, we talked at the last working group that the state bar was thinking about funding us. There may be different models, but I think from my comments now are really just focused on as long as there's a dedicated, reliable source of funding, you know, that could be worked out in many different ways. And I think the answer on Bagley-Keene is it would have to be addressed by statute, because I think the default would be Bagley-Keene applies unless there's a specific, it's addressed in the statute.
I would think there would be a huge issue with legislation on that, because it's the Commission on Access to Justice, and Bagley-Keene is about giving the public access.
I was just going to jump in. One option that I'd heard discussed as an option for discussion was that the state bar could fund through a grant, whether to the Access Commission as an independent nonprofit or as a part of another nonprofit. And in that situation, you wouldn't be a public agency subject to Bagley-Keene. You would simply be a grantee. And we would obviously have to have some deliverable in return for the money we gave you, whether it was a report or recommendations.
And I'll just say, I don't think transparency is an issue, because I think and it could be part of the foundational documents, I think transparency and open meetings, it's just the technical requirements of Bagley-Keene are the problem. I don't think there's any interest in the commission being a secretive, non-transparent entity. The question would be, do we have to, you know, if somebody's calling in on the phone, can they participate as a member of the commission? So it's on the technicalities, but I think the idea is to be open and transparent anyway.
At the risk of creating dissent where there isn't any, I do think there's a huge disconnect in the Access to Justice Commission saying we don't want to be part of Bagley-Keene. I think that while it can be a little uncomfortable to deal with Bagley-Keene, I think that there's probably more value than not many times in dealing with Bagley-Keene. So I think we can figure something out. We've managed. With all due respect to Selena, I don't think what's caused a lot of the problems in the last 18 months is Bagley-Keene. I think there's other issues that have stopped us from moving forward.
One of the biggest challenges, though, is publications, as she was describing. I mean, the sections each had their separate publications. They found they couldn't collaborate if they had more. They couldn't have 3 editors for a publication anymore, because any group of 3 or more with any type of authority cannot meet outside of the open meeting laws. And publications especially require a lot of collaboration and work that needs to happen outside of a public meeting situation, like emails,
joined the
changing
conference.
drafts, and so forth. Yep, Margie?
Yeah, if we're going to be talking about legislation that's going to go before my committee, I'm going to recuse myself from the discussion entirely, and possibly, it's just, you know,
Fair enough.
It is legislation that would be going before my committee. These are issues that I've consistently analyzed. This is my issue area. So if that's where we're, you know, sort of headed towards, are we going to get out of Bagley-Keene or not? And am I going to participate in that discussion? It's not appropriate for me to take part in a discussion about a piece of possible legislation that will be going to my committee.
I don't think we need to get off. I appreciate that.
Yes.
I don't think we need to get off track on talking about Bagley-Keene or not talking about Bagley-Keene. I think more what's more concerning to me is if we end up independent, how do we get funded? What does that look like? Those kinds of things. And I don't know whether that, I apologize, whether that also creates a conflict for you.
Could you repeat that? I'm sorry.
Right. I think my concerns is if we separate from the bar and become a freestanding entity of some sort, where do we get money for that?
Right.
How, does that come through a legislative grant, question mark? Does it come through an MOU with the bar, question mark? Does it come through some other funding, some other source, question mark? And I don't know whether that also causes a problem for you or not.
Yeah, possibly. I mean, this is something new, sort of having, I'm not the legislature, I am an analyst for a committee, and that is
right.
Obviously, the legislature is going to do what it's going to do, and the elected representatives are going to do that.
Right.
And I can't take an opinion on what that's going to be.
Right.
I don't think anything we've talked about yet would require legislation. To do the grant option, that wouldn't require legislation. We already have the authority to do that. I don't think we can create the entity anymore, the nonprofit. I think that right was taken away.
But they're talking about creating one on their own.
Right, they'd have to go out and do it on their own. The state bar couldn't create it and then you spin off into it, like we did with the sections. The sections, we created it so they could spin off into it, but then it was right after that we couldn't do that anymore. But you could find a way, and I don't think we'd need legislation for that or the grant option.
Oh, so it sounds like of the possibilities that we're just brainstorming at this point for possible, considerations for separation, certainly one possibility is legislation that creates an entity, but it sounds like there's also a possibility of creating an entity that would not require legislation. And that, it sounds like, from what I'm hearing and understanding, the open meeting laws play a big part of that. But I think we come back to the funding question, because I think really, and it sounds probably both of those ways could have funding attached, and there's different possibilities. But I think fundamentally, the idea of separation is, and I think we were in agreement at the last working group, that it would need to be funded for that to work. It couldn't be a commission that is half of its time or more is worried about how it's going to be staffed. And it sounds like, at least in concept, we're getting high-level numbers in terms of what that funding is, between 2 and 3.5 FTE plus some de minimis other expenses, and how it worked. Not clear if that's the right model or not, or the right amounts or not, and if there's going to be additional expenses if it's a separate entity. But at least I think that's the ballpark, and I think funding is the critical question to answer of how that would work, because it sounds like even if there's separation, there can be communication and collaboration, or MRUs, or working together with the bar. And so I think it's the funding issue, maybe Bagley Keene, but the funding issue really that becomes center stage.
I was speaking to Heather Rosing yesterday about this, and she expressed to me that the CLA would also likely be interested in getting involved with the commission somehow if you were to separate from the bar. And I obviously can't speak for the CLA, but you might be able to get additional funding from them. You might be able to house your staff with them in Sacramento. So these are discussions that could be had to find out the feasibility of those things. I know that there's definitely interest of working and collaborating with the commission.
So if it's helpful, can I just ask, I think there's a lot of possibilities for affiliations or not affiliations or how creation, but I think it would be helpful to know if the bar has positions or feelings or thoughts on what the bar is willing or able to do or commit itself to if separation is on the table. In other words, what does that look like from the bar's perspective?
The way I would see it is an MOU would need to be created to ensure ongoing funding through some process, assuming that that's not an issue with general counsel. But I think that the board is very supportive of the commission and all the work the commission does. We want to see the commission survive. I personally think independence gives you the most broadest way to go forward. to do whatever you need to do. And that's what I'd like to see for you. I think the board will do what they have to, that's within their abilities, to make sure that the commission survives. If we can provide an ongoing grant, the board, I think, has the power to do that. And I don't think there'd be much resistance. The only concerns coming up are we're running into a financial crisis going forward. If we can't get a fee increase, our resources, even if the commission were to stay with us, our resources are going to have to focus more on our regulatory functions, which I just hope we don't get to that point and we can get the fee increase. But we have a very, our discipline system requires a huge amount of our resources, and that always has to come first. And I don't think you want to have to suffer as a result of any financial situation the board is facing. But ideally, we get the fee increase and we can continue with commitment. An MOU would certainly solidify that. Going forward, we'd have to write that into the budget each year. So that's how I would see us being able to do it. I think it's an easy sell, as long as it's not, such a huge amount of money that it's going to impact a lot of things.
And the one thing I would note, obviously, the bar would continue to be funding the staff that currently reside with the bar who would be doing the access related work, the overlap work, if you would. And so sort of, I don't know that sort of, I don't know what, it's not as if we'd be taking the resources that go to 2 FTEs and just transferring them over, because we're still sort of paying for those 2 FTEs. So we just need to, as Joanna said, sort of need to figure out sort of what the budget would allow. But I think there's, sort of from everything I've heard individually, there's, sort of commitment to ensuring some ongoing funding, contracting back with an access commission to provide support for sort of the overlap, right? That would be the deliverable, would be sort of the access commission providing input to help the bar annually establish what its access priorities should be and helping carry out those access priorities. And I'd also encourage us to think about, in addition to the bar, there are 14 other appointing authorities. Would there be funding available from other appointing authorities, from the legislature, in addition to funding support from the bar?
So if the staff stay with the bar and you'd have a contract, what are the grant funds for?
Their own staff.
So you would provide grant funding for, okay.
Yeah, they would be able to retain their own staff, and use them in accordance however they want. The state bar staff would stay with the state bar. We still have access and diversity initiatives we need to follow, and the priorities that the board has set. So there's still going to be work for the staff that are currently doing that, even if the commission were to separate.
But the state bar access staff that would support the commission would also be doing the state bar's access work.
So the state bar's access staff would be doing the state bar access priorities. What I see sort of the contract with the Access Commission would be a contract for the purpose of the Access Commission assisting the state bar in developing their annual priorities and providing support in carrying out those. But the state bar staff would be doing those priorities. The priorities outside of the state bar identified access priorities would be done by Access Commission staff, not by state bar staff.
Which would be funded through a grant with the state bar, possibly. That could be a possible funding source.
Yeah, I mean, I can't commit here, we can't commit here.
Right.
We'd have funding to support X number of FTEs, but certainly that's, it would go to sort of support the deliverable I mentioned, and could be used for sort of however that gets used to develop, to provide the deliverable.
So if the commission staff is funded through a grant, and hypothetically, if that grant comes from the bar, normally the grantor will have requirements for their grantees. And most of those requirements are, or normally the requirements would be in alignment with the grantor's mission and goals and not anything broader than that, normally. So aren't we back to the same issue?
I don't think so. I think the point is well taken, because this is the oversight part without the control, right? So I think the oversight, it would still, if it's a grant, if the commission is a grantee, there would need to be some kind of reporting and communication, and there would still be the overlap and working together in an MOU. But I don't think you necessarily, depending on how you set it up, have the same issues if the bar is comfortable with the commission as an independent entity taking positions that aren't approved by or under the control of the bar. And again, that could be set out in the MOU that, and again, this is the solution. The independent entity is the solution for the bar no longer needing to exercise control over publications or lobbying or any kind of public statement. Again, there might still need to be a disclaimer. I mean, there could, defining who or what the commission is, but the idea is it would not be speaking on behalf of the bar. So I think it could be worked out in the MOU or in some sort of disclaimers. I think for me, it comes down to the funding, because I appreciate the idea of a grant and the concerns about the financial ability and what that looks like. But this is sort of fundamental to if this option makes any sense, because the question is if it's for the first year you're okay and then you're on your own, or we just don't know what the financial future is, or it's just a big unknown. It's a lot to say, commission, go fend for yourselves. So it feels like there needs to be some sort of reliable source of funding.
And we were also talking earlier about if there are priorities of the commission that are not in conflict with the state bar, but are not the same priorities as the board, they would have to get their own resources for that anyway, even if they're part of the state bar. So that piece of it really is no different. The difference is by taking them out from our umbrella and making sure you have funding of some amount that's comfortable going forward, you would have the independence that you're looking for without having to get the blessing of their decisions to file amicus briefs or pursue legislation.
So I may have misunderstood, but I think it's great to talk through this, because I do see it as very different. If the funding is going in a grant or some other form to a separate entity that's commission, it seems like the commission should be able to use that funding for all of its priorities, as opposed to only certain ones that the bar approves. Again, assuming everything it does is under access. So the idea is, I think the change is the conflict issue, not the Venn diagram where there's certain things the commission's not doing. And that would be important, because I think the benefit of one of the main benefits of a separate entity is that you don't have any of these. It solves the resource issue, it solves the conflict issue, it solves the staffing, different model of staffing issue, and it really comes down to a stable source of funding, and maybe the open meeting laws and things like that, depending on how it's set up. But if that's not the case, I think we need to be very clear.
Well, I would agree. That would be ideal. I get the impression that's not an option, and I'm not an expert on how these grants work. So, Joe, do you want to weigh in further?
Well, I'm familiar with grants at the Judicial Council, and I know if we're providing funds, even if it's to a trial court, we'll have requirements outlined in our contract with individual trial courts. But what that money is used for is not ever going to be not in line with what the council's strategic plan and priorities are. Maybe the state bar functions a little differently, but that would be unusual.
I'll jump in. I think that there's some flexibility, and maybe grant was the right word. You might want to think more as a vendor with a contract. So in other words, we're saying it is worth X amount for us, for you to make these recommendations, and we recognize that, you know, as part of developing your expertise, you're gonna be doing all sorts of activities, so we're paying you X amount, do your work, and come back to us with these deliverables, and we're not really concerned with how you actually spend that money to get there. It's really more of a contracting situation than a grant.
Yeah, that would be ideal. You turned your mic.
If they're bringing the deliverables back to the bar, those are deliverables the bar would want.
Yeah.
Correct, and would need, but to take the example of recommendations, X amount that we give you, if you put an hourly rate on that, just for the, you know, amount of time it actually took to write the recommendations, that would be a lot of money per hour, when in reality what we're paying for is your expertise and all the work and the experience that you're putting into these recommendations over the course of the entire year. I don't think that you can necessarily tie the dollar to the activity in the way that you would with more traditional grants.
So why couldn't you do that in the current, with the current structure then? I'm not understanding then.
Well, then you're part of the bar, so everything you do is technically the bar.
Because they're not a separate entity right now. There's not a 501c3 that we can give the funding to. Right now, they remain under the bar, and so they're under our oversight.
And I get that piece of it, but if they're a 501c3, you give them money, go off and do whatever, but you know, we want these 10 recommendations coming back. Isn't that what they're doing right now for you?
Yeah, so the difference is sort of narrowing, as I see it, sort of the contract that we would enter into would say that the Access Commission is going to, you know, annually present recommendations to the Board of Trustees on for access priorities for the board to adopt for that year. And for all of the access priorities that the board adopts in that year, the Access Commission will partner with the State Bar through the State Bar staff to achieve those priorities. So those are the deliverables for that, right? What I want to caution is sort of absent some dedicated funding stream, because we are continuing to pay to provide the State Bar resources, the staff resources that are doing the access work, and they would be the ones that would be partnering with the Access Commission on bar access priorities. I think it unlikely that we would, you know, have funding for, you know, an additional 3 FTEs that, you know, we'd be able to provide. So that, I just want to caution that, and it's why I suggested, you know, maybe there are some, you know, sort of other funding sources in addition to what the State Bar will be able to provide, right? Not just our resources, but some monetary funding as well. But, you know, if there are additional resources out there in addition to sort of the contract dollars that the State Bar would be able to provide to do sort of the work sort of outside those priorities, that would be probably be necessary.
Right. So the commission, if it was a 501c3, would need to secure funding from somebody other than the bar for all the things that the MOU does not cover.
Correct.
Well, I think that's not quite true. When you contract with, say, an IT vendor, you say, here's the deliverables I want. They can use that money to pay their rent, to work on other projects, to hire their staff. They can use that money any way they want, as long as they produce the deliverables. Yeah. So I think that's what we're saying, is if it's a contract, you give the money, the commission delivers the deliverables, but how it uses the money is up to the commission then, as long as the deliverables are achieved. There's no, you don't restrict if it's by contract, you don't restrict what the money is used for, as long as the deliverables get done.
And that is stable, ongoing, definite funding you will get forever, is what the MOU would outline?
Yeah, so that's, I'm sorry, Toby, go ahead.
I was going to say, you can't promise that.
Any government entity can
exactly.
say that.
Right. And on top of that, from a policy level, this discussion makes me feel like we are turning the commission into a vendor or a grantee, just like any other vendor that the State Bar Board hires on a yearly basis. And to me, it seems more tenuous than I'm comfortable accepting at carte blanche, especially given what I think the board's commitment to access is, right? Just, to me, it seems less important than the commission is and has been. It's almost an optics thing. But more than that, it's a reality thing. If every year the commission has to come in front of the board to renew their contract,
Absolutely.
it's are we gonna get tied up in the little picayune details of we didn't really get the deliverables we wanted, so we're gonna give you less money.
It sounds like there would be significantly greater risk separating like that, especially if you're, without stable, and I emphasize the word stable funding, I think it puts the commission at significant risk.
I think that's right. And from what I'm hearing is the amount of funding probably isn't going to be sufficient either. If
Yes.
it's fully funded through either a grant or a contract, there needs to be an
Some
additional
fundraising
source,
or
exactly,
something.
some other source of money, which
Mhm.
again, this is what we need to talk about, and where does that money come from? What does that look like? How much is it? Because I don't think it's a really viable option if it doesn't come with funding and the commission's now a vendor or really on its own for a big part of its work.
And I think in terms of fundraising, I think that the commission is going to be sensitive to the fact that we don't want to be competing with the legal services programs and going after the big firms and the others that the legal services programs get their money from.
Yeah, I don't think we really can fundraise in that way. I think it's just, I can't fundraise, Mark can't fundraise, and Selena, is so busy, and you send her out, she's split 4 different ways from funds. We cannot fundraise. The point came out about our stability. Joanna asked last time, why would we want to be part of the state bar? And the reason is we have prospered because we've had the stability, and we haven't had good staff. We've had excellent staff from the state bar. There's just, it's at the top, the staff we've had, and the help we've had, and the professionalism, and setting up all the calls, and all the follow-up, and the graciousness with which that has been done has been really positive to us. And so that's why is we have been stable. We can't fundraise. We can't be worried about. All of us are on multiple commissions, and as everyone is. We don't have time to ask people for money, to ask, justify ourselves to the state bar every year. We need stability, and we need stability that we don't have to think about because of a position we might take. And I would also add that, just the sense I have from being on the commission the shortest time is we do need this part where there's this direct conflict that we might have and we might be precluded from taking a position. It's rare, we've all acknowledged that, but there's just a sense that a commission with some degree of autonomy to take positions that are perhaps unpopular is what the Access Commission is. That's the heart of what we do, so it is important. And I think particularly because we're in the state of California, which the other places in the country and in the world look to us as progressive and being out front. So of course we need to be able to take autonomous positions and to be able to say things that are unpopular or in conflict with anyone. That's the essence of Access. And I know from being in the room with the commission for the several reasons that I've been participating, it's very strongly how the commission feels, that we need to be able to take, and maybe it's hypothetical, it probably is, that it doesn't happen, but we still need to be able to take those positions if the situation should arise.
I have a question. I think I heard Selena say that there's been very excellent staff members by the State Bar that used to support the commission. I'm wondering what happened to the staff members and why they're no longer supportive. You just talked about how there were these excellent staff, top Right. Are they no longer in existence or, I'm sorry? They're not, you don't have any staff that can support the commission or?
We do have staff that support the commission. We have, excuse me, a number of staff that have been providing support to the various committees and working groups or the commission as a whole. And we are continuing to provide that support.
The 3.5 full-time equivalents, that's still ongoing?
No, what I had said was that it ranged from probably 2 to 3.5, and it's certainly, I would say, more at the 2 level currently.
Oh, maybe I misunderstood, but it sounded like they weren't receiving the same support that they were receiving historically.
Well, sure. I mean, if you talk about the difference between 2 and 3.5, then certainly it's.
I mean,
it's
today,
less.
are you guys receiving the support that you need to do your work?
So if I could just address this, I do think there have been some turnover. So there are particular people who we had the majority of their time in the past who were excellent that aren't with the bar anymore. But I also think there's been a fundamental change in how staffing is being handled. And in the last year and a half, I don't want to misstate, but this discussion has been ongoing. So we actually have made dormant some of our subcommittees and aren't focused on the same work that we've been doing. So the work hasn't been the same level. And just one additional point of what Selena was talking about in report writing, that's a particular thing that the commission does. And so for the reports that we're currently writing, I don't know that bar staff is participating or supportive of that. And I think that's one of the comments that Selena was doing. In the old world, in the prior staff, we had more staff support on those types of projects. That was really helpful. In the last year and a half, that has all been pro bono of either commission members, pro bono help, or some of the other appointing authorities taking on a lot more of that work. So I think that answers it.
And that's certainly sort of a function of declining resources as well, financial resources. The bar has been, had to make decisions in a variety of areas and how to allocate existing resources and positions to not fill when they become vacant. And so that's just sort of ongoing administration of a large organization and having to figure out how to do that and sort of what to provide the staff resources for. The Appendix I discussion, as Amos was alluding to, did put, that as opposed to staff resources per se, put a lot of the work on hold, as well as some vacancies that we've had. Our director of the Office of Access and Inclusion position has been vacant since February. I'm happy to say that I've got 5 interviews scheduled for Tuesday. So that position has been vacant. There's sort of a number of positions in the office that we have been forced to keep vacant due to resource constraints.
And one other point I'll add, and Donna, please correct me if this is wrong, but I do understand that the model going forward is different than the model previously on staffing. So as I understand it, we previously had the majority of 1 or 2 or 3 people's time, and going forward, the model is we'll have a small percentage of many more people's time. And that, I don't know how that's going to work, but that is a concern. Again, the separation, I think we'd staff it differently. We'd have full-time equivalents, is at least what I understood would be the model. So to continue sort of how it's worked, again, we've had a historically wonderful working relationship with the bar, and we have been able to make it work. But the model's changing, so I don't know what that looks like going forward.
So I don't know if this is an inappropriate question, but I'm going to ask it anyway, and if it is, somebody can tell me. What about being funded in some way through a checkoff on the bar dues bill, or a carve-out of bar dues, or something along those lines? And I don't know whether that puts you in a bad place. I'm just asking the question.
The legislature would have to do that.
Would have to do that, right? That would be a statutory change of some sort, right? Just, yeah. A legislative response.
So Margie can't participate in this discussion.
Yeah, so I mean, one of the things, certainly for the voluntary contributions, one of the things that is an unknown
It seems like there is a pool of voluntary dollars that are contributed, and the sort of more things that you add to the voluntary contribution list, the amount doesn't get bigger, it just gets distributed differently. That's in large part probably more theory than science. I mean, I think, Judge, we always talked about it, in the courts in terms of the filing fees and where's the sort of the tipping point, or the fines and fees, and where's that tipping point. And so there's certainly that issue with the voluntary side of it. On the sort of adding it to the bar dues and X dollars shall go to, there's certainly a question that I've heard some in the board express about the precedent of identifying a non-bar entity that that funding would go to. If what we're talking about is $1 from the bar dues of all active and inactive licensees shall go toward access functions, and it could support what happens at the bar and what happens and what the bar contracts for. That may be another way to look at it. And I mean, certainly, right, one of the other big things is we certainly don't want to sort of negotiate against ourselves. We have been very clear and will continue to be clear about the need for a significant bar fee increase that we need, and that's sort of to support all areas of the bar. And so one thing that we want to be cautious about is taking away from, say, for example, to use an example that works well for this perspective, taking away from the discipline function to support the access function. So it'd just be a balance.
Or the bar decides that what it wants to ask for is a $75 increase. Problem with your hands.
You have to add another 50 cents for that.
Yeah, but let's instead ask for 76.
Right.
And the extra dollar goes for the access.
Can I ask again, because it comes down to knowing the math, what an extra $1 or $2 means in terms of the license fee? So
there are 190,000 active licensees. So if you're talking, $1, it's $190,000. $10 is 1.9 or so.
Which would barely fund a position with bennies and loaded.
Right. So watching our time a little bit, it's 1 o'clock. I don't know. We have another meeting coming up. I'm sorry. We have another meeting coming up on Tuesday, the 27th at 1 o'clock at the bar offices in San Francisco. I think that probably the place to start is maybe here, to give some people a chance to think a little bit more about funding and cost and all of those sorts of things. Is there any other information or homework or any of that sort of thing that we would like to see gathered together for the next discussion?
This is Allison Merrily, just chiming in with some public comment again.
Yes, please.
I think we think it would be, from our perspective, it would be really helpful to have a proposal from the commission itself about its preference.
Okay. I think we can do that.
And for that proposal on the funding aspect of the separation, to the extent that's part of it, I think that's sort of the key on that side. I think on the other side, and it might be helpful from the bar, or of course the commission can work on it too, on the, I think the criteria about the parameters for dealing with conflict and what that would look like in the hybrid model, and what is a conflict with the state bar, how broad or narrow is that when there's a conflict, and that parameters. Again, that might be something for the whole working group to discuss. It might be something to come back with some proposals. But I think on the separation side, the real question is funding, and I don't know if the commission knows what the possibilities are in terms of, besides grant or contract with the bar, what else for the additional stable funding? So maybe some suggestions for that to start off next time would be helpful too.
Okay. I think we're done. If nobody else has a comment, we will go ahead and adjourn.
Happy Thanksgiving, everyone.
Thank you.
Have a safe holiday. And thank you very much.
Has left the conference. Has left the conference.
Jim Herman.
Has left the conference.